to the fourth case on today's docket. It is case number 113579 in the matter of Joan Hawkins.
May it please the Court, the Office of the Disciplinary Administrator appears by Kimberly Knoll, Deputy Disciplinary Administrator. Mr. Chief Justice, I'd ask for 3 minutes for rebuttal.
3 minutes is granted.
Thank you, Your Honor. The first subject I'd like to talk about is the standard of review in this case. Supreme Court Rule 211F requires that in disciplinary cases, the standard is clear and convincing evidence. That has been defined as facts, as asserted, are highly probable to be true. And the Ireland, Lober, Dennis, Walsh case, and of course BDY all cite to that. And in fact, in the BDY case, this court adopted the main Supreme Court's position that had been expressed in the Taylor case, that the rationale that was contained in the Horner case that talked about the quality of the evidence was incorrect. And this court determined that the fact finder must be persuaded on the basis of all the evidence that the moving party has proved their factual allegations to be true to a high probability. And I know this court is also aware that generally you give the same deference and dignity to a final hearing report as you do a jury verdict or a decision of a trial court. So in this case, the disciplinary administrator's position is that the hearing panel's findings are all supported by clear and convincing evidence, with the exception of the 2 points that we abandoned based upon the Gerleman opinion. And I'll talk about that in just a minute. I don't believe I have enough time to actually discuss each and every finding and all of the supporting evidence, but by way of example, I will give you one situation. The respondent maintains that she did not call the Jefferson County clerk and tell them that she was not going to appear. The clerk actually made a notation, and the panel actually found that that was a violation of KRPC 3.3A1. And that was based upon the clerk's action after the phone call. The clerk told her boss that this conversation had occurred. Her boss told her to memorialize it. And then after the hearing in which the respondent reiterated to the trial court that she never made those statements, the clerk made a second memorialization talking about how upsetting it was for her to listen to the respondent listen to the respondent's lies. The panel found that the deputy clerk's testimony was credible and the respondent's testimony was not credible. And the Comfort case stands for the proposition that when there is conflicting evidence and testimony, that the fact finder, in this case the hearing panel, had the ability to observe the demeanor of the witnesses, to evaluate their credibility, and this court does not reweigh the evidence or pass on the credibility of the witnesses.
Well, let's move to another one.
Yes.
The clear and convincing evidence that this has to do with the withholding of the quitclaim deed and the email that was kind of used as leverage to settle the case and to drop the attorney fees. There was an email, and you refer, and the hearing panel refers to the email as satisfying and showing that it satisfied that there was some sort of leverage used to dismiss the appeal. And I've read the email. I don't see that. So where's the clear and convincing evidence of that violation? The reading of that led to the finding of that violation.
Okay, well, first of all, I think you have to look at the whole process of the deed. The deed, I believe, was executed in October of 2013, which is not contested. That's in the record of Volume 3, page 781. The deed did not get released until 2014, and that at record Volume 2, page 194D to 195D, the respondent explained that she did not release the quitclaim deed because there was no order requiring her to. But at the time she released the deed, there still weren't any orders. So the question becomes, what was a precipitating factor that caused her to release the deed? And I would propose, one, the complaint had been filed, and two, that they had made it clear that they were going to go forward with the appeal regardless. And I would suggest to this court that that email was a last-ditch effort to avoid having the sanctions continue.
And where do you read that?
Well, when she says, I'm willing to sign a stipulated joint dismissal if you file a document in district court that the attorney's fees judgment will not be pursued. Absent there being an agreement not to pursue the attorney's fees judgment, I intend to proceed with that appeal. That relates directly to the production of the quitclaim deed to resolve everything. That's our interpretation of it, and I believe that was the panel's interpretation of it. So if this court finds that that is not a high probability of how the events, I mean, obviously that's why we're here. As far as the issue that was abandoned, we conceded that the violations in KRPC 3.4 and 8.4D as it relates to the adoption records in the Gerleman opinion are controlling. I would note that the panel did not have the ability to consider the Gerleman opinion because the panel report and the Gerleman opinion both were issued on the same day. Finally, just because the opinion made a contrary finding on one point, it does not necessarily mean that it's all, that Gerleman case becomes mitigation. That opinion does support the panel's findings that the respondent's actions frustrated the course of the divorce action and that there was injury. My last point is that charging
What's the injury?
The injury was to the time, the drawing out the length of time, additional attorney's fees.
They didn't award attorney's fees. They didn't find injury as a result of that, did they? In the appeal, they found that no, there was she didn't do anything that violated in at least her obligation. She said, "I will provide you the copies of I will provide you, provided you pay for the copies. I'll go to Kinko's, or you go to Kinko's, copy them."
Right.
And that didn't result in warranting attorney's fees to be awarded. How did that frustrate anything?
Well,
Basically, the Court of
It
Appeals
was-
absolved her of her conduct relating to that accusation.
relating to the adoption records, but the way at least I read the opinion was that the trial court was frustrated with both sides. Both sides were behaving, not necessarily moving things forward. And I think the overreaching, her instructing a JG not to answer the questions in the depositions, the quitclaim deed, there was overall a delay. And I think that opinion, when they write that respondents' actions frustrated the forward, that I'm paraphrasing, frustrated the forward progress of the case, does build in injury to both clients who maybe have additional court hearings and additional attorney's fees, as well as just being able to resolve this. They had several different hearings kind of over the same, plowing the same ground. The final, charging KRPC 3.3 and 8.4C is not impermissible. In Kansas, the only KRPC that is truly a catch-all is 8.4G. That was not charged in this case. And this court has found that the same conduct can support a finding that an attorney violated both 3.3 and 8.4C, which are the Dougherty case, the Shepard case, the Shriver case, and the Orrick case. And in fact, the Woodring case was decided under KRPC 8.4 without any subsection being cited. And in fact, the court just found misconduct. This was an original action in attorney discipline. There were 4 cases over 3 days worth of hearing. The panel found violations of 7 different rules, some of them in multiple cases. At the panel, the recommendation was nothing less than indefinite suspension with a strong recommendation for disbarment. There were no mitigating factors found. There were only aggravating factors found. And under the ABA standards, I believe indefinite is the threshold from which to then apply the aggravation and disbarment can be supported. I would ask if this court considers a lesser sanction, perhaps the 18 months or the year that was recommended by the panel, that the court consider ordering a 219 hearing. I'd stand on my brief on the remaining, unless the court has any other questions.
Any more questions? Thank you,
I
counsel.
think I missed what your recommendation is.
Nothing less than indefinite with a strong recommendation for disbarment.
That's your recommendation today?
Nothing less than indefinite? Right, it remains what I asked for at the panel.
All right, I misunderstood your earlier comment. Thank you.
I apologize if I misspoke.
May it please the court. Holly Perkins on behalf of respondent Joan M. Hawkins. There are 4 complaints against Ms. Hawkins. And I think when people think about 4 complaints within a certain time frame, there's this initial thought of she must have done something that violated the rules. There were 4 complaints. She had to have done something. But I think it's important to look at each specific complaint versus looking at them as a whole, and therefore avoiding a punitive discipline against Ms. Hawkins. Upon receiving the panel's report, we filed a significant number of exceptions to the report. And a significant number of exceptions were filed to the report because we did not believe that the findings were supported by clear and convincing evidence. We did not believe that the findings were true to the highest probability, that the facts that were found were true to the highest probability. We believe, therefore, that the panel's report and the panel's recommendation should not be accepted because the report is against the clear weight of the evidence and because there was sharply conflicting testimony and there are sharply conflicting facts as shown in our brief and as shown as we showed in our exceptions to the panel's report.
Well, let's start with the one that Ms. Noel pointed out at the outset, and that has to do with the clerk in Jefferson County. And as I understand it, there was evidence taken from your client, but there was also evidence presented from the clerk, from the other party's attorney. I believe the district court judge there was at least a hearing on that, and they made a determination, a credibility determination. Why isn't that clear and convincing evidence of a violation? Just because it's contested and your client has a different version doesn't make it not clear and convincing, or that they've made a finding that satisfies the standard, does it?
No, it doesn't. But I would argue that Ms. Hawkins
it just seems like every single point was contested. Everything.
It was.
I mean, you didn't concede anything, which is your right to do. There's no question about that. But that's just an example of, well, what's the problem with that? Tell me why that isn't a finding that should stand.
Ms. Hawkins showed up. She showed up that day for the hearing. And I truly believe that had she told the clerk she wasn't coming, she wouldn't have come. And she came at 3:30. And there's the evidence that shows...
I understand she showed up. There's no question about that.
Right.
She 5 minutes late or something. And then she said she thought it was at 3. But nonetheless, there was still a credibility determination made by the hearing panel. Based upon
there was.
Just what you're saying, based upon what the clerk said, and the evidence taken, I think, at the next hearing I think there was a judgment entered as a result of her not being on time. But so I'm back to where what are you contesting here? You're just saying she showed up, we should revisit that finding?
Yes. Yes.
And how do we get there without reweighing the evidence?
Through the briefs I mean, through the arguments,
One of the places where I had trouble with that was on the, I want to make sure I get this pegged right. The unearned legal fees to MS, did I get it pegged for you?
Yes.
And the respondent had, and the client wanted their money back, and the respondent said, well, we'll get it to you with a full accounting, and that's what you said in your brief. But nobody explains why it takes 3 months to do this full accounting, which, you know, I mean, I practiced law for a long time, and I know it doesn't take 3 months to do this. And so that would seem to indicate to me a violation by failing to timely refund unearned legal fees. So,
I think the one thing, and you will hear from Ms. Hawkins, and the one thing that is a clear theme throughout all of these matters is that there was a practice management issue. And I think Ms. Hawkins has had a practice management issue. And one of the things that we have talked about in should she be able to continue to practice, what does she need to work on to continue to practice, and that is practice management, and she needs to get control of that practice management. And so I think part of, in response to why did it take 3 months, she was having some issues with time slips, I believe, and she was needing to get more proficient at her practice, at running her practice as a solo practitioner, is not having someone there to help her run her practice. And I think that that's one of the things that happens is that it took 3 months. You know, she got her the refund, she did, you know, provide her full accounting, but it did take a long time.
So your position is basically any of the findings that would result in discipline were as a result of practice management issues as opposed to any direct or deliberate, such as telling her client not to answer questions at a deposition.
No, I don't think telling
That's
her
not
client.
practice management.
No, that's not practice management. I think Ms. Hawkins truly believed that they had provided the information to opposing counsel already. It had been a 9-hour deposition. They had been there all day. Her client was emotional. Her client was tired. And she made the strategic decision, right or wrong, she made the decision because she knew that opposing counsel already had the information. She made the decision to tell her client not to answer. End result is the opposing side already had the information. So she wasn't denying any information to the opposing side. I think it's probably best for you to hear from Ms. Hawkins now.
May I ask about one other
Sure,
point
of course.
first? We've talked about some of these situations where the panel evidently made a credibility determination. Would you agree that that was also the case on the idea of whether the temporary orders in the one divorce case had been agreed to by opposing counsel? There was a credibility determination made by the panel
yes.
on that too.
Yes, I would
Thank
agree
you.
with that.
Thank you.
Thank you, Your Honors, for giving me this opportunity to speak with you today. My name is Joan Hawkins. I'm a solo practitioner in Lawrence, Kansas. I've had my solo practice since 2003. First 8 years of my practice, I had an independent practice, but I worked in the same office as an attorney who was much more experienced as I, in order to be able to gain benefit from that relationship. By 2010, I had outgrown the small space allocated to me there, and I've had an office on my own since 2010, which I have downsized since these complaints have come to the attention of discipline. My areas of practice are domestic, criminal law, some general practice things, child need of care, related areas. On a personal note, I've been married for 18 years. Also on a personal note, back in 2012, was a personally difficult time. I live about 8 to 9 hours from where my family lives, and started getting phone calls that spring from family that I needed to get home, that they didn't think that my mother was going to be there for very long. That happened to fall in this kind of time span where you have some of these situations that came up as far as the file and the refund and the court appearance and so on and so forth. It probably wasn't until later, once I was able to get things organized and get myself, I needed to get home, so it needed to happen. And there were other conflicting issues as to why there was a lot involved in me being able to make that happen. And I can say that once that did happen, then, I mean, it was almost like a door opened. I didn't even realize at the time that I was kind of, I don't know if I was in an underwater mode. Did I know it was 3 months? I'm like, I can't believe that took me 3 months. I mean, that's not me. That is not what I believe in. And, I've, in discussing it with a professional, I said, I don't understand. That's not me. I wouldn't tolerate that. When you're in a situation like that, as I understand, you think you're thinking clearly, but you're not thinking clearly, and time goes, and you come in every day and you have the checklist, you don't move through your daily activities as you should. So it certainly wasn't, and I don't say that as an excuse, but there were some things going on, and in self-reflection and in growth, it's helped me to understand how that impacts my ability to provide quality legal services in order to manage my practice, in order to be able to communicate well with colleagues. There is no question I have made mistakes in practice. I strive to be perfect, but I am not perfect, and I do make mistakes. And I deeply regret making mistakes, because I hate to hurt people's feelings. I hate to not give somebody what they asked for. I hate to let somebody down. I mean, if it's not a client, it's a colleague, it's a judge, it's a friend, it's an attorney, it's, Your Honor. I don't want to let people down. And I do take it to heart. And when things are brought to my attention, I like to fix them. In some of these cases, I didn't even know there was an issue until the complaint was filed, like in the journal entry, that I had left a paragraph in there that I should not have left in. Had I known that sooner, we would have corrected that issue. I am very regretful that actions or inactions on my part have brought me here today, or is taking up your time, has taken up the time of discipline. A lot of people have been affected by the fact that my actions, as inadvertent as they might have been, have happened. I take this very seriously, and the things that you see in the record that I did or did not do, I did not do any of those with an attempt to gain an unfair advantage or to thwart the system in any way, or to take advantage of a client, or to, be tricky. Really, there are unintended consequences to actions or inactions that I take. Whether I thought it was right at the time or not makes no difference. It falls on me. It's my responsibility, and I need to own it. And I own these things openly. I am an advocate at heart, and perhaps in advocating for clients at times, I sped something up that I shouldn't have sped it up. In retrospect, would I go back and do that again? No. And then, you get a client that doesn't have a lot of money, and so, you try not to have any unnecessary court appearances because they don't have money to pay for that. So all of this is in advocating for my clients and helping them to achieve the goals that they have set out for themselves.
Counsel, at some time before your time runs out, will you or your counsel tell us what it is you're asking us to do?
Well, I want a chance to redeem myself. I mean, ultimately, just as I said in the original question when it was posed to me by the hearing panel, they asked me what I wanted. I said I would like to be exonerated. You know, sure, I would love for that to happen. But, you know, if I need to show this court that I am worth having in this profession, that you think that there's something here worth saving, that you think that perhaps with some direction or some chastisement or reprimand on your part that needs to happen, I am accepting of that. I believe in continuing legal education. I'm glad that there's now law practice management we can take as CLE. Reaching out to colleagues for help and advice to continue to become more proficient. Also to work on demeanor and working with others. And, you know, even if there are certain attorneys that I don't naturally work well with, working well with that, you know, and talking to other senior members of the bar and say, when I get in this situation, you know, do you have some advice for me? That's always kind of been my fallback. As a matter of fact, the day I got back from the hearing in Jefferson County, I called one of those mentors and said, this is what happened. I can't believe this is what happened. So on and so forth. I have already downsized so that I have fewer cases, less responsibility, more manageable, can pay more attention to detail, be more focused, and spend more time, have more balance between work and life. That is one thing that I learned in the first office I was in. You have to have a balance. And the profession itself is relational, in relating not only to clients, you know, but also to our fellow professionals and within the community as a whole.
And if we do not exonerate you, what is your proposed action that we take?
Yeah, I think that my legal counsel is probably better able to answer that.
Well, one of the things I was wondering, you sound like you're asking for help, or you're appreciating the fact that changes need to be made. Would one of those be a supervised practice for a period of time, something like that? I mean, this is the first that either Ms. Knoll or the hearing panel has heard of anything like this. So
yes.
I'm just what are you talking about here?
You know, all I can tell you is I'm open to accepting help. Whatever help that you think is appropriate to me. I am not reticent. I am not saying I have the answers. If that means I need to be checking in, or I need to have somebody looking over my shoulder, or, you know, if you think that that's what this record shows, that that's what's required.
Well, what do you think?
I think I've taken the first initial steps of, well, first of all, identifying areas to work on. I have downsized. I think shifting my focus. I'm doing less domestic because that seems to be the area that all of these issues have come up, and perhaps maybe the emotional side of that maybe is not well suited for me spending that much time. The one case in particular, I mean, that case is still ongoing. Issues are still outstanding.
The hotly contested divorce, that one.
Yeah. In managing those things, I think, narrowing my focus and maybe not doing so much of that kind of work would be perhaps something to do. I think taking additional law practice management courses, maximum number, to make sure I mean, I have talked to different people before. I mean, that's how I kind of got email a little bit under control and so on, you know, techniques to bring into the office place. I will be honest, I have been reticent, you know, when I lost my last staff person to replace because, you know, I feel like my practice is somewhat sort of kind of up in the air. And it has been, you know, because I don't want to put myself out there and, you know, be bringing in staff and so on and so forth, and then I've got to let them go. So that, in a way, I mean, even though it said, you know, keep practicing, but you know, you know, that's a responsibility. But that's an easy fix. Instead, I just kind of downsized everything.
And I go back to my question, counsel, what it is you're asking us to do. I posed it to your counsel because when I asked you that question earlier, you deferred to her.
Oh,
So I'm
I
looking
apologize.
at her.
Oh, I'm sorry, if you don't exonerate Ms. Hawkins, we would ask for something very similar to the decision that you made in the Rumsey case. I understand that probation has not been asked for and a probation plan has not been put forth in front of the disciplinary administrator or in front of this court, but we would ask for something similar to that. So a stay of a suspension with a probation plan put in place that allows Ms. Hawkins to continue to practice, but also allows her to address some of these issues that she has spoken about today.
Very well, thank you.
Thank you.
Can I just ask a quick informational question? At what point did you retain counsel to assist you with this disciplinary proceeding?
See, I went on, I don't know if it was when I got the second letter.
Well,
I
in
had
advance
retained-
of the hearing date.
We were not initial counsel.
Okay,
No.
We were second counsel.
Yeah.
Yes, we were second counsel. We
okay,
were-
but you had counsel from the time that you got the second or third disciplinary complaint?
I think I filed, I don't think I had any assistance drafting any of the
Informal responses?
informal responses. I don't believe. And I'm
Okay.
sorry that my recollection is not
Thank
better
you.
than that.
All right, thank you both.
Thank you.
Thank you.
You reserve 3 minutes for rebuttal.
I would waive rebuttal unless the court